So yeah, without further ado, I'd love to introduce Stephanie Boyce, our keynote speaker. Stephanie is president of the Law Society and the first Black person to hold this role. Stephanie was admitted as a solicitor in 2002 and has a wealth of experience in corporate governance, regulatory frameworks, and professional regulation. Stephanie is a council member of the Law Society representing the Women Lawyers Division, a solicitor member of the Joint Tribunal Service, and holds a number of statutory appointments with her local authority. And in 2020, Stephanie was voted onto the governance Hot 100 and made the Power List 100 most influential Black people in the UK in 2021 and 22, which is just incredible. So Stephanie, the floor is yours.
Thank you very much for that introduction. And can I say it's an absolute pleasure to be able to speak with you all today. So I would like to focus on the criminal justice system, the pressure it is facing, and what the Law Society is doing to address them and support practitioners. You are all on the front line of the justice system and will know as well as anyone the challenges facing our justice system. It is no exaggeration to say that it is the effort and goodwill of practitioners and stakeholders keeping the criminal justice system running, despite the tremendous pressure it is under. Much like the NHS, our legal aid system provides a key public service. It is a fundamental principle of British justice that no matter your wealth or position in society, when you find yourself having to go to court to resolve a legal issue, you should have access to a committed lawyer to provide the support you need. And they will act as a guide, providing counsel and being a staunch advocate for you until justice is done. But in recent years, and through governments of all varieties, the system has not seen the investment and maintenance it needs. It has been 25 years since there was a significant rise in criminal legal aid rates. The lack of a rise in rates has, of course, been compounded by inflation, heaping on pressure. The story of this lack of investment can be best told through the numbers of criminal legal aid firms, a third less today than 9 years ago. Each lost firm means fewer practitioners to respond to an ever-growing number of cases. However, the recent publication of the Independent Review of Criminal Legal Aid may mark a turning point. It has recommended an increase of at least 15% in criminal legal aid rates. And this would go some way to reversing some of the damage that has been done. The review also acknowledges that chronic underfunding of legal aid has meant further investment may be needed if we are to address issues in the criminal justice system. Many of the report's other recommendations echo policies the Law Society has been calling for and which we put forward in our submission to the review. And this includes setting up an independent advisory board to help develop a more joined up approach to criminal legal aid, as well as regularly reporting to the Lord Chancellor. The review also calls for the Magistrates' Court standard fee scheme to apply to work done at police stations and in the Crown Court. We have welcomed many of the recommendations in the review, but above all, we welcome the sense of urgency it conveys. Its chair, Sir Christopher Bellamy, acknowledges that there is no scope for delay in implementing its findings. The Law Society's focus is now on ensuring these recommendations are implemented as quickly as possible to halt the erosion of criminal legal aid firms and to shore up the sustainability of criminal justice system. The government has said it will respond to the review's report by the end of March, and we look forward to seeing their response and hope they will adopt the recommendations in full and implement them with urgency. Our justice system is like an ecosphere. If you change or alter one area, it will have an impact across the landscape. As such, you can see some of the consequences of the underfunding of legal aid being borne out in our courts. As of October 2021, the backlog in the Crown Court was just below 60,000 cases, and that remains true today. That figure represents justice delayed and lives put on hold for thousands of victims, witnesses and defendants. And with cases being listed into 2023, some users of our justice system may begin to question the value of justice that arrives years later. The situation was not created overnight, and though worsened by the pandemic, it was not its chief engineer either. Years of underfunding, cuts to legal aid, court closures, and caps on judicial sitting days have all conspired together and resulted in the backlog we are responding to today. If we are to maintain public trust in our legal system, more must be done to tackle the backlog. The government has begun to recognise the issue and take some of the steps we have been calling for to address it. Last year's budget saw welcome investment in the Ministry of Justice, including funding committed specifically to reducing the backlogs. And when taking into account the recruitment of new police and case demand on the courts, the government has said it expects the new funding to see the backlog reduced to 53,000 by March 2025. So while it is pleasing to see future demand on the system accounted for, we must see more ambition from the government and the backlog lowered further if we are not to risk the public becoming cynical about timely justice and the rule of law. In years to come, extensive delays, cancelled trials and backlogs must be looked back on as an aberration in our justice system, not a feature. So the past 2 years have also brought the use of technology in the justice system to the forefront. We have seen a broad move to remote hearings, and with this has come fundamental shifts in the trials or in how trials are conducted. In many instances, remote hearings have been more convenient, accessible, and time and cost effective for advocates, parties, and judges. They have minimized travel time, which has had a positive impact for people with long commutes or childcare commitments. They have also provided a better work-life balance for many and have subsequently contributed to improving well-being. Our justice system is over halfway through its court reform programme to modernise the court and tribunal system. The aim of the programme has been to create services that are digital by default and design, including digitising paper-based services, moving cases online, and introducing remote hearings. The pandemic significantly sped up this process, and the Law Society has been broadly supportive of the programme, provided that access to justice is protected. And this has not always been an easy process. It takes time and money to train lawyers, members of the judiciary, and the public on new technologies. This is a reminder that the technological revolution that is rightly lauded for its advantages has cost too. In addition, there have been questions about the impact of the changes on access to justice for some clients. We know the most vulnerable can find it difficult to engage with remote proceedings. Our own research found that only 16% of solicitors felt vulnerable clients were able to participate effectively in remote hearings, and only 45% were confident that non-vulnerable clients could do so. We must also not discount the negative impacts on practitioners and judges too. HMCTS published its own research at the end of last year, which found that 3 in 5 judicial respondents and just over half of legal representatives felt that remote hearings impacted their health and well-being. Remote trials will become a permanent feature of the justice system, but we must ensure that they do not curtail justice. HMCTS must properly collect data on the effect remote hearings have on the most vulnerable and ensure that all users are able to engage fully with their case and are properly represented throughout. We need to assess fully how judges and practitioners experience cases, especially views on remote hearings could change as the government's Plan B restrictions are lifted and COVID-19 cases begin to ebb. And of course, there are other areas where the use of technology would be inappropriate. Legislation moving through Parliament would enable juries to be able to hear cases remotely, a change the Law Society opposes. There has been little research and no assessment by the government of what impact this change could have on cases. We do not know how jurors would interpret body language or how effectively they will engage with a case heard remotely. Ministers have indicated they have no intention of implementing what would be an expensive and technically challenging change. But if that is the case, it is hard to see why laws need to be passed to make the case against the change to parliamentarians. It's easy to become disheartened when we look at the litany of challenges facing the justice system, but I remain optimistic. Recent reviews have reiterated the arguments many of us have been making in the sector for years, and the government has begun to put in place some of the investment so badly needed. I'm reluctant to announce a turning point, but it is undoubtable that we have momentum behind us to drive real change and put the justice system on a sustainable footing once again. And we must continue to advocate and argue for a well-funded justice system, because if we do not make the case, no one else will. So thank you very much for listening to me. I'd be delighted to take any questions that you may have. Thank you.
Thank you so very much, Stephanie. I would like to open the floor to any questions. So if you'd like to put up your hands, your virtual hands, or make any comments inside the chat, and we'll pick those up. Can't see any hands, so oh, there is one. Kate, we will kick off with you, Kate. We can't hear you, Kate. Okay, I shall move on to Lucy, and then I'll come back to Kate, and hopefully we can hear you then.
Oh, good afternoon, Stephanie. That was absolutely inspiring. Thank you so much. I'm from YME. We're a restorative justice organisation, and we promote access to restorative justice, but I'm particularly interested in the court backlog you were talking about, and your view on the use of out-of-court disposals to clear some of that backlog. So rather than just kind of pushing everything through the court. You know, we wrote a report last year, like looking at if you could use out-of-court disposals to go through the backlog and say, are some of these appropriate perhaps to be addressed in using out-of-court disposals, which would also enable victims to be consulted on their wishes.
I think it's an option that obviously needs to be considered, but I think it's got to be, you know, each case has to be taken on its own merits, its own circumstances. Individuals involved in that particular case has to be consulted as to whether or not, you know, they agree to that. But it is another option possibly that is available. Obviously, what we say is that, you know, investment in the justice system is needed, however you come to it, or indeed however you exit from it. The criminal justice system, and indeed across the piece within the courts and tribunal system, there is underinvestment. You know, the infrastructure there itself needs heavy investment. And we have seen this in the autumn budget, the recent commitment of funding, but the money is needed now rather than, you know, when the government comes to it, or spread over 3 years as they've suggested. It's long-term investment that is needed for all the reasons that I've highlighted as well, but it's that continued underinvestment over successive years that has got us to the point that we are at today. And if there is not further investment, continued investment, then practitioners will vote with their feet and they will leave the profession. And we've seen that, you know, criminal legal aid deserts that exist around the country where individuals are not able to access legal advice. So however they come to it, as I say, the important thing is that individuals can access advice when they need it.
Thank you.
Thank you. I've got a couple of questions in the chat, and Lindsay Owen would like to know your view on today's proposal to allow magistrates to impose sentences of up to a year.
Well, absolutely. The Law Society does not support the increase in powers to magistrates, nor do we view it, nor do we believe that increase in magistrates' powers is going to reduce the court backlogs. As I mentioned, there are some under 60,000 cases in the Crown Court. Magistrates' powers are appropriate for their current powers of being able to sentence for 6 months or less. Any increased powers should be dealt with in the appropriate forum in the Crown Court, where there are complex cases that need specific skills and experience in order to address those cases.
Thank you. Sorry, I was on mute there. I've got Kate's question, which actually refers to kind of being on mute, but she says she sees many issues with remote trials. So for example, how will they ensure that the jurors are alone and are actually listening to the case? She also says that she thinks that there are other ways of dealing with the backlog. One would be to look at different ways of diverting cases early on, putting real community provisions in place to deal with people and focus on more serious cases. Is there any move to do that? And what are your thoughts on her comments?
Well, as you heard me say earlier, the Law Society, we oppose remote jury trials for some of the reasons that you've already amplified. The concern is, of course, how do we preserve the integrity of our justice system? We are, one of the tenets of our democracy is that we are judged by our peers, by individuals of our peers. But the concern is, how do you know? You don't know who's in the room with me now. We don't know how individuals may be influenced. As I spoke about earlier, about body language, how people read body language, eye contact, and so forth. So the Law Society is against remote jury trials. We do not believe that they will enhance our criminal justice system. There are other ways that the government should explore. One of those that you have mentioned, that is for the government to explore those. We believe that if your liberty is at risk, that you should be in a room with others in order to ensure that you have representation, specific representation. You can access that. We know that technology is great. It works when it's all good, but when it doesn't work, and to suggest that somebody's liberty is at risk and their internet cuts out, or they've missed some of what the judge is saying, or the jury is picking up incorrectly individuals' body language, eye contact, that is a risk too great.
Fantastic. Before I go to Nina, because I think your hand up for Stephanie, I'm going to get a few more from the chat. A question from Helen. She said she heard this morning that barristers are leaving the criminal sector and that this is due to the backlog and the pay. What are your thoughts on this?
Well, exactly. That's my reference to practitioners will vote with their feet and leave the criminal justice system. As I mentioned, 25 years of continued underinvestment. Criminal practitioners must be given a fair rate of pay. We are willing to work with the government, but there must be proper investment, proper rates of pays. And we know, as I referenced earlier, that there are criminal legal aid deserts around this country where if you are arrested, you cannot or are not able to get criminal advice or legal advice in respect of criminal matters outside of the police station duty scheme. There are real issues with our criminal justice system. And if the investment is not there, then of course practitioners, as I say, will vote with their feet, whether they are barristers or solicitors, and they will go to other sectors, to other professions that pay them a fair wage.
Thank you. Just some comments as well about the previous question. Penelope was saying that her understanding is that the government envisages that all jury members would be together in a conference room, video linked to the court. So would there be any further thoughts around whether this would be something that could be done, or What do you think, Stephanie?
Well, I haven't heard those specific proposals, but as I say, the Law Society remains against remote juries, because that goes back to the same point that, okay, so perhaps it takes away the aspect of whether that particular jury is in a room by themselves being influenced by others. However, we still have issues around connectivity. We still have issues around body language, eye contact, and so forth. If my liberty was under threat, I would want to be in a room with my peers so that they can see the whole of me, as opposed to what is being conveyed over a computer screen.
Thank you. The questions are coming in thick and fast in the chat. So another one from Thomas Hollick. Is there evidence that pressures on legal aid and access to justice is exacerbating existing racial inequalities in the criminal justice system?
Well, we know even before the pandemic, we know, given David Lammy's report on the experiences of Black, Asian, minority ethnic colleagues, or those defendants, excuse me, those who are in the jury, caught up in the criminal justice system, that there were inequalities. Of course, the pandemic has exacerbated those inequalities. And as well as that is the concerns that we raise around individuals, around vulnerable clients, around individuals, and being able to access justice. So we know the pandemic has had an effect on individuals' experience of the justice system. And that's why we are calling for continued investment for all the reasons I've already outlined. So individuals can get advice when they need it, and appropriate advice from a legally qualified, regulated, insured practitioner.
Thank you. Over to Nina. And then if there are any more questions after that, please put your hands up.
Thank you, that was really fascinating. Just wanted to come back up, links on very well to that point about equalities, and I know that something you're passionate about is increasing diversity of people both in the legal profession and also the judiciary, and it's something that CJA have been working on, looking right across the criminal justice system. What for you would be some of the key things that you think would make a real difference in improving particularly racial representation in the legal profession and judiciary?
Well, firstly, one of the things I speak about is about increasing diversity and inclusion in the profession, and I'm talking about across the legal profession, not just the solicitor profession. We know in the solicitor profession that 17.5% of our members come from a Black, Asian, minority ethnic background. So that's about par on par with the UK population. We know that there is an overrepresentation of Black, Asian, minority ethnic colleagues in the justice system. So we, the Law Society, are working with colleagues, with firms, with workplaces, in-house colleagues, to ensure that the profession represents the communities that we serve, that there should be greater representation throughout the professions at senior levels rather than junior levels, to ensure that individuals can access advice as and when they need it. From individuals, because we know that individuals do engage better when they are able to converse with somebody who they best connect with. So it's important that our profession represents, as I say, the society that we are serving.
Thank you. Is there any further questions for Stephanie? No, I've just got a couple of comments. I don't know, would you like me to read them out? One comes from Kate. She says, little seems to be gained by using a remote system if they all have to collect together in one space. The only advantage might be to ensure jury members in rural areas can participate, especially if the accused is also from that area, ensuring local justice. However, a better way to achieve this would be to facilitate cases being heard in rooms which are not court buildings. As noted, even if the jury are together, there are issues with their ability to properly engage and understand the proceedings. Okay, well, if there's no further questions, thank you so very much, Stephanie, for joining us today. We've really appreciated having you here.
Thank you very much for inviting me. Thank you.
So thank you everyone for your questions. Before we head on to the panel discussion, I just wanted to bring in Nina, our director, to talk about an exciting announcement we'd like to make on a project that we've been planning over the last couple of years, it feels like. Nina, can you tell us a bit about what the inspiration was behind it and what the project is?
Great, thanks, CJ. Yeah, we're really excited to be able to launch today a new programme that's been a long time in the making. It's a lived experience leadership programme, and it really sort of was inspired by the work that we'd done a couple of years ago. Many of you will know that we produced a report called Change from Within, that really kind of spoke to people with lived experience of the criminal justice system working in the sector to think about, you know, what are the barriers to progressing their career. And one of the barriers that came out from that report was a lack of leadership support for people to navigate their careers and to move into more senior leadership positions. And one of the recommendations from that report was to design a leadership programme to support them as well as employers in the sector as well. So we've been working and co-designed a leadership programme called Elevate, CJS, which stands for Elevating Lived Experience, Voices, Advocacy, Training and Expertise. And it's also partly inspired by my travels about 5 years ago as part of my Churchill Fellowship over to the States, in California and New York, where, you know, I was really blown away by how many lived experience leaders were, you know, really kind of leading the criminal justice reform agenda. And the common thread between them is that they'd all been part of you know, various leadership programs in the States, one of which is called Just Leadership USA, which I went back to visit their offices, really inspired by their work. So it's been a long time in the coming, but really thrilled that we're now able to get this project underway.
Amazing. Can you tell us who Elevate is aimed at?
Yeah, so it's going to be a London-based pilot, so people in Greater London. We're hoping to then evaluate it and then roll it out to other parts of the country after the first 2-year period. And it's aimed at people working in the sector already who are in roles, for example, working as peer mentors, like the project you support at St Giles, CJ, where people are going to schools, doing that kind of frontline delivery roles within the criminal justice sector, but who are possibly experiencing a glass ceiling of being able to sort of being sometimes pigeonholed in those roles in service delivery, but who want to move into more senior positions, into influential positions to influence system change, whether that be in the civil service, whether it be in the charity sector, the public sector or private sector. We want to support people who are working in the sector who want to kind of reach those different levels. And we also take a very broad definition of lived experience. So it's not just people who've been in prison, but it's people who might have convictions, people who might have been over-policed, people who have family in the criminal justice system in prison, and victims of crime as well. So we've taken quite a broad definition of lived experience.
Yeah, I think that's really important. So what will the programme involve?
So it's quite an intense programme. It's a 12-month programme that people will apply for and be selected for. We're hoping to have a cohort of 20 at a time over this 12-month programme. It'll be a mixture of in-person and online. So there'll be residentials. That was an element that the Lived Experience Expert Group was really committed to, that there should be safe spaces for people to come together to discuss their experiences throughout that, as well as getting a mixture of individual support through coaching and mentoring. There'll also be work placements with employers, and we'll work directly with employers as well to support them, as well as clinical supervision support for individuals as well to support them through that process. So it'll be quite an intense programme, but a fantastic opportunity and lots of resources and lots of support for people who want to take that next step in their careers.
Sounds fantastic. Where was this 5-10 years ago? Can you tell me a bit about how the programme was designed?
Yeah, so as you know, CJA, so CJA, for those of you who don't know, as well as being a trustee of the CJA, chairs our lived experience expert group that meets several times a year. And as well as producing the Change from Within report, has then been working over the past sort of 18 months on co-designing this lived experience leadership program, because of course you don't just want to take a model from the US and bring it, to the UK. We need to grow it organically here to fit in the the environment that we're working at and to meet the needs of people here in the UK. So our lived experience leadership group have provided huge amounts of advice. We also had one of our Longford interns, Jason, who carried out a whole range of interviews with people, so doing peer research to really kind of understand the barriers and what we need to put in place to really make this work. But it's a pilot, and we're not going to get it right the first time completely. So we want to evaluate as we go along, so that we can then make amendments to make sure we really are providing what people need during that 12-month period, and then hopefully we can kind of roll it out further afield as well.
Fantastic.
And I wanted to sort of ask you, CJ, as your role over the past 2 years with this role, and as a leader with lived experience yourself, what do you hope that this programme will achieve?
I think this programme really gives leaders with lived experience an opportunity, a real opportunity, to develop and become the next generation of our sector leaders. And I'd like to see graduates of the programme being elevated into positions where they can really influence change. And following on from the learnings of many great other leadership programs worldwide, doing something similar, we need to have those closest to the problem a part of the solution. And this really will provide a more formalized progression route. You've talked about all the support that's in place, the fact that it's been designed by people with lived experience, to support these emerging leaders on that journey. And ultimately, the aim is to create systemic change in the criminal justice sector and better outcomes through better informed decision-making by those individuals.
Absolutely. And as I mentioned, one of the key bits of feedback from the expert group was about this dual-pronged approach, not just working with individual emerging leaders, but also working with employers in the sector. So can you just explain a bit about why you think that's important?
Sure. Well, we can't just develop leaders with lived experience and not work with employers and key stakeholders in the sector. We need to ensure that there are inclusive working environments, that like barriers to progressions are removed and people feel able to bring their whole self to work. They're not judged, they're not stigmatized, they don't feel like they can't talk about a certain element or be kind of proud that the fact that they are, they are experts by experience, but also by the professionalism and everything else they've learned along the way. So they're not held back by that lived experience. And I think it's a bit of a journey that we need to go on. So to be able to do that at the same time would be fantastic. The programme needs to support employers to understand both the support needs for people with lived experience so they can really flourish, but also the benefits of this type of leadership, which I think there's a lot of lip service around, but I don't actually think we walk that talk at the moment.
Yeah, absolutely. I think people get the kind of, the value of people with lived experience in those delivery roles. I think it's now taking it to the next stage about, that value to, all different stages of the system and in decision making and commissioning and designing of services, as well as delivering them. Absolutely. So our next steps is to recruit a project manager with lived experience to lead this programme. What will they be doing, CJ, and what sort of person are we looking for?
Sure. So, John, I saw your message in the chat. Don't give up. This particular role, the project manager, they will lead on finalising and implementing the project plan for the leadership programme. So that will include getting facilitators in place, really we've done the initial work, but we want it to be theirs. We want them to own it and to further develop it and, be able to do things like source and manage the logistics of the venues, the technology, how's this all going to happen in terms of the program delivery. They will also be developing relationships with employers, designing resource and toolkits for the employers to support them before, during and after the placements so that we improve the employment practices and policies within those placements. And they'll also be working with the policy team to influence change to policy and practice with ministers, senior civil servants, commissioners. So really exciting stuff to actually remove barriers for lived experience leaders, alongside doing comms work, some line management and the learning and development work as well. We are looking for someone who has a strong interest in and is committed to lived experience leadership. So ideally, it's somebody who has lived experience themselves. Again, we're using this broad definition of the criminal justice system in England and Wales. They've got at least 3 years experience of relevant work. This could be paid or unpaid, and experience of sort of managing projects and budgets. We actively welcome applicants from Black, Asian, minority ethnic communities to apply for this role as well. And I think the ad's going to be live on Friday. So
yeah, on the Friday. So the job will be live on Friday. It'll be in our bulletin on Friday. So yeah, I really encourage everyone on this call and others to, to spread the word, to share that rollout with anyone that you think, might be interested in your networks and others. So we get the farthest reach as possible for that role. So yeah, that'll be out on Friday. And just want to say a big thank you to the 2 major funders for this, which is Lloyds Bank Foundation and Trust for London, as well as a few small others. So a big thank you to them for allowing us to start this project. And yeah, if anyone does have any questions or wants to find out more about it, please do drop me an email, and I'm happy to speak to anyone about it.
Yeah, thanks for all the comments in the chat as well. I'm sure that the project manager or the team will be in touch as we start to scope out different placements and employers that we can work with as well. So I'm going to move on to our panel discussion now. So let me just, there we go. So we're going to be kicking off with Penelope Gibbs. Welcome, Penelope. Thanks for joining us.
Thank you.
So Penelope is the founder and director of Transform Justice. She worked in radio production and at the BBC before being inspired to influence social change in the third sector. She set up Voluntary Action Media Unit at Time Bank before joining the Prison Reform Trust to run a 5-year campaign to reduce child and youth imprisonment. And she's also sat as a magistrate. So welcome, Penelope, and I'm going to hand over to you.
Thanks very much. And I'm going to talk about threats for justice, but I almost don't know where to start on this one because there are so many. But first of all, I'm just going to read an excerpt. So in May 2020, I was very worried about what was going on in the courts. It was the beginning of the pandemic. The courts were still running, but nobody seemed to know what was going on in them and how defendants were faring in them particularly. With great difficulty, I did get into the public gallery of magistrates' courts, and with my heart in my mouth, I did some live tweeting because I'm on the margins of being allowed to. And here's just something from watching those magistrates' hearings. A woman appeared on video from police custody. Her lawyer was on a different video screen, but no one seemed to know why she'd been detained or what offence she was accused of. We waited and waited as the lawyers and the legal advisor tried to work it out before the judge understandably lost patience and broke for lunch, leaving the poor woman still in police custody. In another case, the judge asked the defence lawyer whether the figure on the video screen was his client. The lawyer said he didn't know, since he'd never seen his client. That defendant had serious mental health problems. So that lawyer had tried to speak to the client in police custody, but hadn't even had a phone conversation before that client had their first hearing on video in the magistrates' courts. And is this new? Is this video linking and difficulties, even knowing what the case is, new? Unfortunately, I was looking at my blogs on my website, and I and Transform Justice have been campaigning on this since 2013. So we're talking years and years, but unfortunately the pandemic has accelerated this program which was mentioned and by Stephanie, the digital court reform program. It's cost billions, literally billions, and they have been building up to it all these years. And in the pandemic, it just exploded. And I want to talk really about why all the evidence shows that it isn't about access to justice and can be negative about access to justice. And when we talk about access to justice, I get a little bit impatient about all this stuff about convenience. Yeah, we all want convenience, but surely convenience is the lowest common denominator of access to justice. That actually fair trial rights and people understanding what on earth is going on comes above convenience. If we can do convenience too, great. But it shouldn't be the be all and end all. Convenience either for lawyers or for defendants or witnesses. And this is the kind of mantra that comes up in terms of the digital court reform program. So what I'll say about the digital court reform program is that it involves in the criminal courts having many, many more people on video links, both witnesses and defendants. To me, the jury trial, you know, it's interesting, but is not going to affect, even if they do it, which are unlikely to do, that many defendants. Whereas day-to-day video links affect a lot. And so it's what happens in the magistrates' courts in this, which is always been my focus. And can I say, most defendants never go to trial. So this emphasis on the trial is distorting everything. Most defendants plead guilty, but it's incredibly important what the process is that deals with those defendants who plead guilty and why they get to the point of pleading guilty. So what happened in the pandemic is that they brought in the emergency COVID legislation, which, sorry if you can't hear me very well, we've got kind of building work outside. So the emergency COVID legislation brought in many more kind of provision for video links, allowing for video links in practically any circumstances anywhere. You could do a trial on a video link in the magistrates' courts according to that legislation. And apparently some were done entirely on video. Again, we don't know much about it because it was so difficult to get access to what was going on in hearings. So massively more video links. Where this made a difference was police custody into court. So they started up these things which are called video remand hearings, but really it was police remand that referred to. So these are first appearances in the magistrates' courts, which was the ones I was observing. And they video linked a room in police custody to the court. So the defendant was on video link, and then they had to somehow get a consultation with a lawyer before that hearing from police custody as well. And I think that was even more difficult from what I can work out and talking to lawyers than actually the hearing itself. And then you've got the normal video links with prisons, which have been going on for years. And then actually they video linked into the community as well. So many defendants were allowed to take part in their hearing from their home, which wasn't necessarily their home, actually, from wherever. So they could do it from a car, from a shop, you know, wherever they were. If they had the video link, they could do it on their mobile phone, and witnesses too. So, you know, it was routine for witnesses in the magistrates' courts to appear by video link. And also probation. Nobody talks about probation, but there was an absolute revolution in probation's engagement with defendants in terms of it's all gone to video link. It almost all that initial engagement, assessment, etc. So it used to happen that probation engaged with people in the prison via video link, but not in court, whereas now that it's gone entirely that way, and we have no idea what the impact of that is because nobody's done any research on it. But I have some concerns, as I think anybody might, about the idea of how you can have a full and frank and a conversation with a probation officer who you've never met before on a video link. And then the other key difference, and Stephanie referred to this was about lawyers. So always previously, the only interaction that lawyers had with their clients on video was when they were in prison and they were trying to do a consultation before a remand hearing or something like that. But nowhere else, elsewhere, they would meet with them at the court, or they would meet with them in police custody. But what happened was, when somebody had been arrested, the lawyers had withdrawn from police custody. So a lot of the advice given to suspects in police custody during the pandemic has been done on a video link or even just a mobile phone. So that's a huge revolution, totally unresearched, apart from by one report done by NAN, Fair Trials and ourselves. And then there's the court kind of interaction again, because lawyers have been working from home. That initial consultation pre the first magistrates court hearing has ended up being, on video or phone. And, again, I think we don't know enough about the effect on the relationship between the lawyer and the client of having it like that. And I'd like to kind of reflect on this vulnerability point. Everybody who's a defendant or a suspect is vulnerable. 100% are vulnerable. Yes, some are legally, technically called vulnerable, but everybody's vulnerable. And therefore, I don't like this kind of, oh, they're okay on video because they haven't got that label of vulnerable or for that matter, disabled. I do agree that on the spectrum of difficulty, it appears that those who have particularly disabilities to do with neurodisability or mental health problems fare particularly badly on video. And when I talk about faring badly, what I'm talking about is, does the defendant or the suspect actually understand what's going on, understand the hearing? As we know, criminal courts are double Dutch, even if you're there, to a lot of people, not just defendants, people watching, whatever. To then be at one remove and not able easily, comfortably to ask questions, to kind of tap and try and talk to your lawyer during the hearing, all the evidence, and I've looked at all the research now, suggests that it's much more difficult to hear and understand what's going on, to give your view, which is about what effective participation is. You need to be, as a defendant, allowed to say something at some point if you need to. And then the other thing which appears to, from the research to occur, and I've seen it too, is a sort of, it can change the behavior of someone. And we know this. We've been on, I'm afraid online seminars a bit like this. You've turned your camera off, you tune out. Now, the defendants aren't allowed to turn their cameras off, but it's much easier to tune out and to just zone out if you can't really understand what's going on and are finding it hard to participate. And it's not the defendant's fault. It is the fault of the system imposed on them, about which they have no choice. And the other thing that can happen to defendants in these circumstances, they get very frustrated. So if you look back to a very old report, but very current, that Transform Justice did a few years ago about video hearings, there are stories of defendants who stand up and shout, swear, walk out of their hearing. Again, we've put them in an inhuman situation where it's their liberty at stake and they can't communicate properly. So no wonder some defendants get frustrated. And then the last thing I want to point out is that there is very worrying evidence that it changes judicial outcomes, that the actual decisions made by judges are different if they see the defendant on video, that there are more prison sentences, more adjournments, and it's indicative stuff. And surprise, surprise, the government has not collected the data to stand it up or not. But, you know, strong indicative evidence from government commissioned research. And again, you know, we know from, if you're on video with somebody you don't know, where you're having it's not where you're sort of, you might need to kind of confront them about something, you wouldn't want to do that on video, would you? You don't have, it's more difficult to get the, you know, the empathy of somebody else and to even just get the understanding. So I'm going to stop there, but I think the threats are severe from the video link revolution.
Thank you so much, Penelope. Really important insights and reflections on the concerning impact of digital proceedings and interactions. We're going to move on to our next speaker. If you've got questions, please hold them to the end. I've got some great comments. I've seen yours, John. I will try and remember to read them out at the end, so Penelope, you can reflect on them. So our next speaker, thank you so much, Penelope, is Louise Shorter. Louise has worked in the field of miscarriages of justice for more than a quarter of a century. She was a producer, director of the BBC's long-running investigative TV series Rough Justice. Louise founded the registered charity Inside Justice, which provides free legal, expert and investigative help to people in prison protesting their innocence. She's on the board of directors of the prison newspaper Inside Time and is a member of the board of the Youth Justice Board of England and Wales. So Louise Shorter, founder and caseworker at Inside Justice, over to you.
Thank you very much. Thank you very much for inviting me. And I'm just going to share my screen now, which I hope you can now see. I've got some slides to show to you. So I'm going to talk to you about the threat to justice, which is the way that fresh evidence is dealt with by the Court of Appeal. So just by way of a bit of background, oh no, why can't I move my slide on? Just a minute, I can't. Yep, there we go. So by way of background, I was at the BBC for nearly 20 years. I spent much of that time working for the very long-running TV series you'll probably remember, some of you who are old enough, called Rough Justice, which investigated claims of wrongful convictions and actually was involved in getting 18 murder convictions of innocent people quashed. And then a decade ago, I set up the charity Inside Justice, and we provide free legal and expert advice to people in prison who claim they're innocent. So the case that I want to talk to you about today, and the threat to justice, as I see it in terms of how fresh evidence is dealt with, is this case. It's our client Patrick on the left, who you can see, and his absolutely fantastic solicitor, Jason Larty, with whom we worked. We collaborated with Patrick's legal team on this case. And this is a murder conviction, and the convictions, I'm pleased to say, have now happily been quashed. So I'm just going to give you a little bit of background about the case. This is a murder case, a joint enterprise case from 2017 in North London. This is the victim that you can see on the screen. He'd had his throat slashed in a flat in North London. So say it was joint enterprise. And the prosecution rounded everybody up, and everybody who was present, they rounded them all up, and they were all jointly convicted of the crime. Two of them were convicted of the crime, regardless of the role they'd actually played in the case. So our client Patrick was convicted alongside another man called Zhao. And there was a third man who also stood trial, who I'm going to refer to as G, and he was acquitted. Both Patrick and Zhao blamed G. They both said he was the guy who was responsible for it. And what was really crucial at the time of the trial was that G was able to present himself as a man of good character. So his line throughout was, I'm the good guy here. These two, Patrick and Zhao, have got previous convictions. I'm good, they're bad. And that was the defense that he ran. Siobhan Gray, QC, was the counsel on the case, an absolutely magnificent woman. Honestly, Jason Larty and both Siobhan Gray worked tremendously hard on the case, pro bono for a lot of time with no legal aid to cover them. And she was absolutely determined alongside Jason to get Patrick's case back to the Court of Appeal once the guilty verdict came in. So she contacted Inside Justice just as soon as that verdict came in, and it was her absolute determination that we should all try and collaborate together, knowing how difficult it would be to get a murder case back to the Court of Appeal. So what we were able to offer, Inside Justice was able to offer, were experts. We had forensic experts, former scientists, and also former detectives who were able to get involved with this case and provide reports and expertise. And we also provided some funding in terms of some new work which was needed, which we couldn't secure any other way. So there were some people in the Polish community who were saying that although G had put himself forward as a man of good character, he really wasn't. He was a threatening, intimidating individual. And that was the sort of the rumour on the ground. But all of the attempts by the authorities to find out if he had previous convictions had turned nothing up. So we paid for a private investigator in Poland to be able to start going and to do some work to try and find out more about G. And it was really quite an old-fashioned collaboration, taking me back to my rough justice days, I suppose, in that TVN, the Polish television station, also took an interest. They started doing some work trying to find out more about G, and they turned up that he had a previous conviction, which had not been discovered by the police, the Metropolitan Police, or the Crown Prosecution Service. And so that truth was uncovered, and it showed that the jury had been given a very false impression of him. And that got the case back to the Court of Appeal. That was the winning ground. But we also put in other fresh evidence, the part that I'm interested in here. Happy days for Patrick and Joel, but some difficult learnings, I think, and more work needs to be done now. And that was really about this previous conviction. So as I say, we had found this fresh medical and scientific evidence, which I'm going to take you into some detail about in a moment. But the Court of Appeal wasn't interested in that. The Court of Appeal didn't like the fresh evidence, saying that it wasn't fresh, that it could have been run at the time of the trial. And so it wouldn't allow that ground of the appeal. And I think that's an issue for all innocent people in prison today who want to bring evidence which hasn't been before a jury back to the Court of Appeal and back to a retrial. So this is a photograph from the murder scene. And the case was, the jury were told at the murder trial that the victim had been fatally injured in the flat, and all of the injuries took place in this room. There was CCTV footage from a neighbouring residential property, which was really helpful because it showed that, first of all, Joel, innocent defendant number one, had left the flat as a sort of raised ground floor area that you can see with the window on the left. So he'd gone out of that window and you could see him exiting the property, coming out, turning left, and he ran up the road. Patrick was very soon behind him, our client Patrick. He also exited, turned left, ran up the road. And then you can see on this CCTV that the victim then exited the flat at this raised ground floor level, came out onto the street and turned right. And then in pursuit of him was the defendant G, who'd been acquitted at the trial. And he also came out, turned right, and went after the victim. And so that was important because it meant that we had the two groups essentially splitting at that stage and going in different directions. Now, when we were back at the trial, Siobhan Gray, counsel, had been instructed on this case very soon before the trial started. And she was always really struck by the crime scene photographs that showed this pool of blood out on the street. And she kept, sort of looking at that and trying to get experts to look at that to say, why isn't this featuring? Why are the police not interested in this blood? And why are the Crown experts not interested in this area of blood from the crime scene photographs? So when the guilty verdict came in, she then set about trying to find new experts. And she found Professor Crane, who was at the Northern Ireland pathologist, and Dr. Klaus Buschmann from Germany, and also Joanne Millington, a blood pattern analysis expert. And she took all of the material to them and said, what does this tell you about the injuries and how this crime took place? Did it all take place in the flat? Or actually did some of the attack take place outside? And if so, which injury? What does it tell us about how this this crime took place. And they all stated unequivocally that the fatal injury, it was a carotid artery, he'd had his throat slashed, but that fatal injury took place out on the street, and it would have been impossible for him to have been injured inside the flat and then to have made his escape as seen on CCTV and to run up the road in the way that he did. So that evidence became really important. But of course, what we know from the Court of Appeal judgment is that they weren't interested. They said, you've given us no reasonable explanation under Section 23 of why this wasn't adduced at the time of the trial, and so we're not going to allow it now. But that evidence, that scientific evidence and medical evidence from 3 experts, that put an entirely different complexion on the case. But as I say, the Court of Appeal wasn't interested in it. The failings to uncover that evidence rested absolutely squarely with the Metropolitan Police in terms of their investigation. You can also then go on to criticise the other experts who were involved in the case at the time of the trial to question why none of those individuals bothered to look, really properly, closely at that evidence and to find out what it told us about how this attack had actually taken place. The one person that you can't blame for it are the 2 guys who were in prison, Patrick and Joel, because their position obviously was they stuck to their account of what happened right from the very beginning, and it was absolutely of no benefit to them whatsoever for that information to have been withheld. And I don't think you can blame the lawyers, Siobhan Gray and Jason Larty, in this case at all, because they were the ones who absolutely stuck to trying to find out precisely what that evidence told us. But if, in terms of the Court of Appeal judgment, which is now, of course, will be read by the Criminal Cases Review Commission, and they will use it, I would say, to bolster their view that fresh evidence is going to be resisted by the Court of Appeal. In terms of our defendants, of Patrick and Joel, that information would never have been put back before a jury if it hadn't have been for the previous undiscovered previous conviction of G, the other defendant. So really important information here, which very nearly didn't get back before a jury at all. So at the retrial, the fresh evidence was admitted, and happy days for Patrick on the left and Solicitor Jason on the right, and Siobhan Gray and all of us involved in the case. But the fact that really important evidence very nearly did not go back before a jury at all, I think is a real problem, and it's something that is an area of research that I want to carry on with. So some of you may well recognise this case. This is a very old case from 1972. A young man called Maxwell Confey, who was found in a house in London. A fire had been set, and he was found and he'd been strangled inside the property. 3 teenagers were picked up by the police at the time. They were held on suspicion of lighting the fires. And they were held without their lawyers being called, their parents weren't being told, and sure enough, at 2 a.m, would you believe it, but they all turn around and confess to the crime. Hardly surprising given the circumstances in which they've been held. But there was also really interesting pathology evidence that came out at the time of the appeal on this case. So when the murder was first being investigated, a pathologist said that the time of the death was at a time when those 3 boys didn't have an alibi. Soon after they'd been convicted, they turned around and they all said, actually it might have been before that, but they turned around soon after their confessions to say they'd been beaten out of them by the police and they had nothing to do with it. And their families and lawyers and their MP, you can see here, all took up a great campaign on their behalf. And part of that work was to look again at the pathology and look again at the time of death, and was the time of death accurate? And what those investigations found was that the time of death was wrong. And actually, the time of death was at a time when these boys all had a really solid alibi and they could not have been responsible for it. Now, there was nothing new. There was nothing any more new about that evidence in this case back in 1972 as there was about the pathology in Patrick and the others' case. It was just better, more expert, more accurate, more that was the right evidence that should have gone back before the jury. Now, back in 1972, when this case, in 75, I think this came to appeal, it was allowed, the pathology was allowed. The Court of Appeal didn't attempt to sort of squash it at that stage and say, no, we won't deal with that pathology. We're going to find a reason here not to be able to let that in. They accepted that the pathology was important and that should have been before a jury. The case also left to the introduction of PACE, the Police and Criminal Evidence Act, which of course was important, but the pathology was not sort of swept to one side under the interest of finality and expert shopping, which is what I want to just come on to before I finish up. The expert shopping, it was established in the case of Jones, which is a case of a police officer who was convicted of murdering his wife. Another interesting case in the miscarriage landscape, if you don't know it, to have a look at. In the recent case of Sally Challam, Lady Justice Hallett there said this court has set its face against expert shopping, and that really does sum up the Court of Appeal's approach to fresh evidence. And that's an interest, I believe, because I think this is a barrier to justice in that if there is something significant which comes from experts, which comes from scientists, because medical evidence, scientific evidence, of course it moves on. And it may be in some cases that you can turn and you can say, well, we are reliant on this new test. This new thing has been done now, which allows us to say it's new. You might be able to do that, but you might not. And you ought to, and for those people who are in prison who are innocent, that evidence should be back before a jury for a jury to decide whether or not it's significant. It shouldn't be dealt with, in my view, by the Court of Appeal. I would say that they are stepping into the role of the jury if they do so. So my questions are that my final points for you to think about really are that, you know, as I say, science moves on. Sometimes experts get it wrong. And that information and that evidence should be back before a jury. It shouldn't be decided by the Court of Appeal that it could have been done at the time, so therefore we won't look at it now. If there is no reasonable failure for it to be before a jury, then that doesn't mean to say that it shouldn't go before them now. If it has a significant effect on the case, I would argue that it should go before them. As I've already mentioned, in Patrick's case, if we hadn't have found that previous conviction, then that new evidence from 3 experts saying that the way the jury had heard that evidence would not be before them, and that can't be in the interests of justice. So the principle of finality, which I'm sure everybody is familiar with, I believe is now overriding the interests of justice, and that can't be right. I want to know, some research has been done on this already. Kate Mallison did her seminal work on the Court of Appeal back in the 90s. There's been some work more recently by Stephanie Roberts, which have looked at how the Court of Appeal does its work and how it's considering cases. But nobody has really looked at this work in terms of whether or not the way that the Court of Appeal is dealing with expert evidence, whether or not that is stopping some cases from even attempting to go back to the Court of Appeal. I suspect that there are people who are being told by lawyers who are correct that the Court of Appeal won't allow this evidence because they don't like expert shopping. And so I would like to hear from people who have any thoughts about this area and anybody who believes that cases may not be going back to the Court of Appeal because of the court's approach to fresh evidence, and also whether or not there is if anybody knows of cases where they believe that fresh evidence should be used, or whether or not they know of cases where the Court of Appeal has certainly said that they won't allow it because of their views on expert evidence. Thank you very much. I shall stop sharing my screen and give the power back to those who know how to use it. Thank you.
Thank you so much, Louise. That was really compelling listening to you talk us through this threat to justice and how the Court of Appeal deals with fresh evidence. So thank you so very much. Our next speaker is Emma Torr. Emma is Appeals Legal Director and in-house barrister. Emma fights for individuals who have suffered serious miscarriages of justice, working closely with appeals specialist investigators to uncover fresh evidence and overturn convictions through the Criminal Cases Review Commission and ultimately the Court of Appeal. Prior to joining Appeal in 2020, Emma worked for over 15 years as a criminal defence barrister. Welcome, Emma, and I'm going to hand over to you.
Thank you, CJ, for the introduction. It's a real pleasure to be able to join you all today. I'm also going to share my screen, so I'll do that now. So hopefully you can all see my screen. I'm going to talk to you a little bit about threats to justice from the post-conviction stage. So following on nicely from what Louise has been talking about and how the Court of Appeal receives cases, I should be talking more about the work of the CCRC. But first of all, a little introduction about appeal and what we do. We are a not-for-profit charity law practice set up by our founder, Emily Bolton, and we represent, like Inside Justice, victims of miscarriage of justice. We are philanthropically funded, but some of our cases we're able to work with legal aid funders. We have a strong pro bono component in our work. We work closely with counsel, with experts, with law firms and students who all advise us on our cases. We're simply too small to be able to screen cases and take things to the Court of Appeal by ourselves. We are an investigation-focused law practice. We, from the very beginning, take cases, look to see what problems may have arisen in police disclosure, police misconduct, whether things may have gone wrong at the trial stage, and try and sort of leave no stone unturned. And we also campaign for system reform. And like Penelope has pointed out, often we see the problems day to day in our criminal justice system, but without speaking at events like these and campaigning together, we're not going to get these problems addressed. So, as I said, I'd like to talk today, if I may, about the CCRC. Louise has talked to you about the difficulties in getting cases to the Court of Appeal and the Court of Appeals, but the way in which they receive fresh evidence, which we wholeheartedly agreed with. What I'd like to talk about is what happens when your case fails at the Court of Appeal, your conviction is not quashed. You have to take your case back. You have to take your case now to the Criminal Cases Review Commission. They were set up as a conduit to the Court of Appeal following the cases of the Birmingham 6 and the Guildford 4, for example. It was set up by statute. It was given powers to investigate cases. It has the power to ask for police files, for CPS files, to instruct their own experts, to interview witnesses. So it has far-reaching powers. And if the CCRC feels that the test for referral is made out, then it sends the case to the Court of Appeal for a rehearing. So the case will have already had a hearing at the Court of Appeal, it's gone to the CCRC and they refer it back. In that situation, the Court of Appeal must hear the appeal. However, it's 25 years on since the CCRC was set up, and the reality, sadly, is that they have unmanageable workloads. They, I think, evidence and experience suggest that the investigations that they conduct on cases are not to the standard we'd expect them to be. It has become more of a gatekeeper rather than a conduit for cases to the Court of Appeal. Again, evidence and experience suggests that it's become overly deferent to the Court of Appeal, and it only sends a handful of cases back. For the hundreds of applications it receives every year, the current referral rate is 1.95%. Those who work in the miscarriage of justice community, I think, will agree that the organisation now lacks transparency and accountability. The CCRC accepts that there are improvements to be made, and they've accepted that over the last decade, because of budget cuts, their work has been affected, and their workload has also increased by about 70%. So we know that there are problems there. And there has been a gradual shift away from thoroughness towards an increased emphasis on efficiency. And again, I think that's perhaps the thread and the theme that Penelope was talking about with remote hearings. Is it about having the justice? Is it about having access to justice and people receiving a fair crack of the whip, or is it about efficiency and savings? Now, there are ways in which the CCRC can investigate cases, and once they have decided that they will take on a case and investigate to see if there has been an unsafe conviction, they have to decide whether or not they will take that case to the Court of Appeal. Their statutory powers are set out in the Criminal Appeal Act 1995, and they can refer a case to the Court of Appeal. But the wording of the statute is quite interesting, because it says that a reference of a conviction shall not be made unless the Commission considers that there is a real possibility that the conviction would not be upheld were the reference to be made. So this is a predictive test, in essence. The CCRC is required to second guess what the Court of Appeal will decide. And Louise already mentioned that her case, for example, involving her client Patrick, will be looked at in due course by the CCRC, and that will perhaps be another example of where the Court of Appeal may not refer a case because expert evidence has been rejected. We feel that that predictive test and asking the CCRC to second guess what the Court of Appeal will do hinders the decision-making and investigation of the organisation. We have to remember that it's not a judicial body. A number of people who will be working on the case, such as case review managers or commissioners, may be non-lawyers. They also may not have been working within the justice system for a very, very long time. The turnover for commissioners at the at the CCRC, they may have a tenure of 1, 2, maybe 3 years. So again, thinking about how long it takes for a case to get from the CCRC to the Court of Appeal, those people may not have the experience that us practitioners have in really framing cases to go back to the Court of Appeal. There's been some research on this topic. Both Caroline Hoyle and Mayo Sato spent time working with the CCRC, and they produced the following book, Reasons to Doubt. And some of the salient points to take from that research, which I'd recommend reading for anyone who's interested in this subject. They found evidence of shared deference to the Court of Appeal, and also discerned a culture that was imperative to keep favour with the court that seemed to go beyond the legal mandate on matters of efficacy. So again, the Court of Appeal, sort of the CCRC, rather than wanting to take cases to the Court of Appeal, is perhaps scared of the Court of Appeal's take on a case, and they are perhaps reluctant to refer cases which otherwise are fairly strong. They also noted a gradual shift away from thoroughness towards an increased emphasis on efficiency. Huge variation between case review managers. Those are the individuals who take on a case, who are in charge of the initial review. They'll be in charge of appointing outside forces perhaps to investigate. They'll be in charge of gathering the evidence, interviewing witnesses, deciding on whether or not to instruct experts. And there can be a huge variation in the amount of work carried out by individual managers. One of the comments which was fairly shocking, which came out of the research, was that one case review manager told the authors of the report, well, it's obvious that most of them have done it, meaning that perhaps they're not taking on cases at face value, and they are receiving applications from individuals who they already perceive to be guilty and whose conviction is safe. moving on from the Sato report, there was in March 2001, what was finally launched after some time during the pandemic being delayed, was the Westminster Commission on Miscarriages of Justice. This was focused on the work of the CCRC and heard evidence from practitioners and from those that lived in experience. And the report concluded that changing the problematic real possibility test might create a different and more independent mindset. And it went on to recommend that the real possibility test should be redrafted to expressly enable the CCRC to refer a case where it determines that the conviction may be unsafe, the sentence is manifestly excessive or wrong in law, or where it concludes that it's in the interest of justice to make a referral. So that's a very different test to the one that's currently in place. It went on to say that while the real possibility test remains in place, the CCRC should be bolder in interpreting it, determining in each case whether there is more than a fanciful chance of the verdict being quashed, even if quashing is less likely than not. We've looked across to other jurisdictions to see how perhaps other countries look at post-conviction appeal cases. There are very few countries which have a system like ours with the CCRC. In the States, for example, there are many routes to appeal at different stages. They don't have the CCRC and then a public body looking at convictions. You can appeal your conviction many, many times. Other Commonwealth countries have a Criminal Cases Review Commission. New Zealand, for example, its test is that their CCRC may refer a conviction or sentence to the appeal court if it feels it is in the interest of justice to do so. So that's a much broader test, allowing those commissioners and case review managers that if they feel there is an unsafe conviction, that it's in the interest of justice to refer the case, they can do so. The CCRC must have regard to several factors, one of which includes the prospects of success at the Court of Appeal, but that's not the determinative factor. The CCRC is therefore able to make its own assessment of the merits of a referral in all the circumstances. Interestingly, Canada is about to launch its own Criminal Cases Review Commission, and there's been some consultation about what test they should adopt for referrals to the Court of Appeal. And what's being proposed is that the Canadian CCRC refer a case where it concludes that a miscarriage of justice may have occurred. This is a much lower standard than that we have in the UK, and it's more generous, of course, than the present standard that if a miscarriage of justice likely has occurred. So this example of a test does not require a probability of a miscarriage of justice before referral. And in the consultation phase, the CCRC, Canadian CCRC, felt that they didn't think a predictive test in the sense that our courts require the English Commission to direct his mind to whether the Court of Appeal would overturn a conviction or sentence would be the right test to adopt. They went on to say that the new commission should form its own independent view about the possibility that there has been a miscarriage of justice, and it should not refer cases only when it is certain that a Court of Appeal would agree. And certainly at appeal, we feel that that's what's happening now in the English system. The CCRC is scared to refer cases. We know that the Court of Appeal over the last few decades has sort of systematically reduce the number of cases that it does, or convictions that it does overturn. And for those reasons, it's getting harder and harder to get cases from the CCRC to the Court of Appeal. So we've thought for some time now as to what the solution could be, and this is something that we're pleased to be able to sort of share with you all today. It's something that we've been campaigning hard on for a number of years, and we suggest that a fresh approach is needed, a new test which uncouples the decision-making of the CCRC from that of the Court of Appeal. We believe that that's where justice is broken down, because the CCRC is bound by a predictive test, because it's so difficult to judge what the Court of Appeal may do. And certainly in cases involving fresh evidence, we know that the Court of Appeal is reluctant to perhaps overturn those convictions. You have examples of evidence being presented to the CCRC. In Louise's case, for example, involving new experts, you may have new witnesses coming forward, you may have advances in technology or in science. But if the CCRC believes that the Court of Appeal would not like this fresh evidence, then it's more likely than not to reject your case. So we would like the CCRC to be able to exercise this independent judgment. After all, they're the ones that can have access to the police files. They're the ones that can instruct experts. They can speak to witnesses, and they have those statutory powers which allow them really to search for fresh evidence. And we believe that the language that was proposed by the APPG is the correct solution, that the CCRC should refer a case where it determines that the conviction may be unsafe, the sentence may be manifestly excessive or wrong in law, or where it concludes that it's in the interest of justice to make a referral. So we believe that this is the best of both worlds, allowing the CCRC to refer a case if it believes the conviction may be unsafe, and allowing it to refer cases where it's in the interest of justice to do so, which really allows them to grapple with those lurking doubt cases where perhaps they've reviewed a case and they believe that the conviction is unsafe, but perhaps as of yet fresh evidence or new advanced technology haven't been found, that those are cases which will end up in the Court of Appeal, which at the moment are being denied access to justice. So we would very much appreciate any views that you may have on this subject. We know that it's very little research has been done either on the CCRC or on the Court of Appeal. And as Louise has said, any if you like, assistance that those with lived in experience or those who work within the criminal justice community have on these threats to justice. And I think, as Penelope and Stephanie pointed out at the very, very beginning, where one part of the system is broken, it impacts on the rest of the system. And if we are able to fix problems in the magistrates' courts with proper access to justice, there will be less appeals. If we're allowed to present cases properly to the Court of Appeal, then there'll be less work for the CCRC to do. But again, we'll have all these circular problems unless we're able to properly fix these threats to justice. Thank you.
Thank you so much, Emma, for highlighting these really concerning threats to justice at the post-conviction stage and sharing Appeal's refreshing new approach. I look forward to the comments and questions for you shortly, so thank you so very much. Our next two speakers are Charlotte Henry and John Crilley. Both are campaigners at Joint Enterprise Not Guilty by Association. John Crilley is to date the only person to have had his joint enterprise murder conviction overturned since the Supreme Court ruling on Joji. He was supported by Jengba throughout his 19-year sentence and completed a law degree while incarcerated. Charlotte Henry is a chartered legal executive specializing in criminal defense. She has campaigned with Jengba since 2013 following the conviction of her brother Alex Henry for murder by joint enterprise. So I'm going to hand over to Charlotte and John.
Great. Who wants to go first, me or you, John? You're on mute. Okay.
You go first.
Okay, cool. Hi, my name's Charlotte. I'm a Jengba campaigner. Jengba stands for Joint Enterprise Not Guilty by Association. Jengba is a grassroots campaign. We were founded in 2010 by Gloria Morrison and Janet Cunliffe. And our primary aim at our formation was to challenge a type of joint enterprise known as parasitic accessorial liability. So since 1985, there have been two types of joint enterprise. The first is accessorial liability. That's where the principal offender commits the offence and the secondary offender or accessory assists or encourages the principal offender, intending to provide that act of assistance or encouragement. But since 1985, there's also existed another type of joint enterprise known as parasitic accessorial liability. This is where two or more people go to commit one crime, crime A, and during the course of crime A, one of the group, the principal offender, commits a further crime, crime B. All that were part of the initial crime would be guilty for the second crime if they foresaw the possibility that the crime might happen. The reason it was fiercely condemned was because instead of intentional participation in crime B, it was enough that the defendant foresaw it in order to be convicted. So Gemba campaigned for 6 years against that type of joint enterprise. And in the case of RV Jogi, we were vindicated when the Supreme Court declared that foresight is no more than evidence of intent and is not to be equated with it. Yay! So at the time, you know, we were all overwhelmed. We really thought that we were going to get our loved ones out of prison or fair appeals. My brother was convicted of murder in 2014 and sentenced to 19 years imprisonment. So in particular, I was really hopeful that on the basis of this change in the law, we would be able to get fair appeals to the thousands of men, women and children convicted under PAL. But unfortunately, those who are wishing to appeal on a change in the law and are serving notice to appeal out of time, which is beyond the 28-day statutory time limit, have to pass this thing called the substantial injustice test in order to have an appeal. The substantial injustice test has been applied in many different ways in the past. Well, not many different, a few different ways in the past. Immediately preceding the Jogi case, the way it seemed to be applied was the Court of Appeal would look at whether the conviction was unsafe, and then in order to pass the substantial injustice element of it, whether the applicant was still suffering the consequences of the conviction. So just before Jogi, there was some death by uninsured driving. It was a change in the law. Previously, people could be convicted for death by uninsured driving, even if their driving wasn't at fault, just so long as they were uninsured and a death was caused during the accident. That law changed, and now more has to be, the defendant has to be at fault, his driving has to be to blame, so to speak. Those people appealed based on the change in the law and were out of time, and they only had to show that their conviction was unsafe and consequences of the conviction. One of the consequences of the conviction, which actually was able to pass that threshold, was a high car insurance premium. So it was financial burden was enough to satisfy that test. When we look at parasitic accessorial liability and what we thought we were going to have to pass, if it was a consequences-based test, then we would automatically pass it, because most people that we support is homicide, so murder, serving a life sentence. They're either in custody or they're serving the rest of the time on life license. That plus societal stigma, I think is well beyond a high car insurance premium. So we expected that if we had to pass that test, that's fine, we'll pass it. But after the Jogi case in 2016, the Court of Appeal heard a bunch of test cases, a batch of test cases in the case of R.B. Johnson. And the court was tasked with interpreting what substantial injustice means and then applying it to an array of cases. I think there were 12, but don't quote me on that. And what they did was they changed the test for us. So instead of a consequences-based test, we had to prove that the change in the law would in fact have made a difference. So comparatively, safety test is around about might the conviction is unsafe, and the error at trial, if corrected today, might reasonably have made a difference. That's roughly what it is, although I don't think it's been completely interpreted before. Whereas the safety test would categorically have made a difference. So would have made a difference versus might have made a difference. It's an incredibly high and onerous legal bar. Only one person has passed it, and he is John Crilley, who's going to talk next. He's also London Bridge hero, the fire extinguisher man. So we've tried to challenge this test at the Supreme Court. So in the case of R.V. Ordu, which followed, that test it was someone that travelled on false identity documents because he was fleeing persecution. They then became available as statutory defence, and the availability of that defence meant he now wanted to appeal and that his conviction was unsafe. But obviously he has to pass a substantial injustice test. So the Court of Appeal looked at how to apply that test to him, and they said that it's only us that have to prove, PAL cases that have to prove that we're innocent. And in Ordu's case, he only had to prove that he was suffering the consequences of the conviction and his conviction was unsafe. He was unable, I don't agree with this judgment at all, he was unable to prove that he suffered the consequences of the conviction. And so he was refused. But I think he should have passed that one on that test. But anyway, yes, so Ordu said, we're the only ones that have to pass that test, reason being that if we had to demonstrate that we were still suffering the consequences of the conviction, we would automatically pass it because of life sentences and societal stigma. So they raised the bar only for us at present. That, in the case of RV Towers, that was a PAL case referred by the CCRC, and it was refused an appeal. But because it was referred by the CCRC, a full appeal was in fact heard, which meant it was within the jurisdiction of the Supreme Court. Before that, in the Johnson cases, we weren't allowed to, weren't within the jurisdiction of the Supreme Court, because substantial injustice is a test that's applied for permission to appeal. And once it's refused, you're not within the jurisdiction. So Towers was the first chance that we were within the jurisdiction of the Supreme Court, but a question wasn't certified because it's the substantial injustice test that we were challenging is only applicable to us and therefore not of general public importance. So without recourse to justice through the courts, Jengmen now have a private member's bill. It was drafted last year and has been circulated around universities nationwide. We benefited, I wrote it, but with the assistance of Felicity Gerry QC and Professor Matthew Dyson of Oxford. We got feedback of 15 academics, and 100% were in favour. It was just tweaking, looking at what we wanted to actually do. What we have decided to do is an amendment to the Criminal Appeal Act, which embodies the consequences test. But our version of which should be a consequence is unspent convictions. So we feel that if your conviction is unspent, so it's either really serious or fairly recent, then you should be able to have leave for appeal, and then the only question is safety. I think that balances really nicely with the principle of finality, and it means that people with less serious spent convictions won't be able to clog up the court system if that was a real concern for parliamentarians. It's not a concern for me, but it will be a concern for them. So I thought it struck a fair balance. Anyway, John.
How do I follow that? You've basically covered everything, I think. Guess I'll just come at it from a victim or a person who suffered this type of miscarriage of justice. I've been, sadly, no longer, but I've been in and out of trouble all my life, in and out of prison. All they ever do in court is tell me to take responsibility for my actions and to give back to society and mend my ways. Yet, after the amazing campaign and the Jogi case, when we was all banging the doors in the prisons and thought we've done it, they just simply shut the door, slam it shut in your face, and it's really only down to saving face, basically. That's all I can see it as. Although they found my conviction unsafe, they still wanted to retry me. I went back for retrial. I shouldn't have done it now. It's the biggest regret of my life. I didn't run the trial. I took a plea. I pleaded to a manslaughter. And again, they've given me 18 years for a one-punch manslaughter that obviously I didn't throw, which is just so disproportionate, it's untrue. It's all just to cover their backs, and it really irritates me that they can get away with it. Like I say, they preach all day about doing the right thing to us, yet when it comes to them, they're just allowed to do what they want. People are serving like 20, 30, up to 35 years. It's in no way comparable to these driving offences, which is where I know substantial injustice to be from originally. So I just don't know how we get away with it and why there's not any more fuss getting kicked up about it, and why it's just left to us and housewives to try and put things right. Even the MPs now, I suppose, if I've got my constitution unwritten right, I'm supposed to take it out of the judiciary's hands if they're not doing the right thing, but they refuse to do it. The Court of Appeal won't even define this substantial injustice test, so we don't know what we've got to pass or what we've got to prove. We can only go off as being the only case up to now of my case, and I was in a far way more than a lot of cases I know of that we've got guilty to an extent of offences of some form. I was committing a burglary, so obviously I deserve some punishment. But we have cases of kids, autistic kids, grandparents, basically just defending their families and then being found guilty of murder. It's just horrendous. We have got this bill going in, so we just hope we can get support and backing for it. I don't trust them, obviously, so. But something's got to change. Something's got to give these people, kids, grandparents, like I say, just suffer, and it's torture. I'm out now, and obviously you get the survivor's guilt. It's just wrong. I don't know how I've got out, because I've read cases and just innocent law-abiding people with no offences at all are just suddenly then found to be murderers. It's just wrong. So I don't know where else to go with it. Just all we do is keep campaigning and hoping that people are going to listen to us and get behind us. It's just not right. And this criminal justice system is a shame. It's not the best in the world. It's absolutely horrendous. So anything we can do to change it for the better. Obviously, I'm out. I don't need to be here. I can be off doing whatever I want. But the pain that I know them people are going through is just I can't rest with it. So if we can get any help at all from anywhere, lobbying MPs, anything, we really, really would appreciate it. And thanks for having us on. Luckily, Charlotte went first and done all the legal stuff. So,
Thank you so much, Charlotte and John. Brilliant and really emotive to hear your extremely valuable insights here. And congrats for your outstanding National Organisation Runner-Up Award as well. I would like to open up the floor to questions for all the panel members. I've been tracking the chat and we've got quite a lot of questions from John, but I'll start by opening up the floor and then I'll go through John's many questions unless he'd like to ask them himself. So is there anyone who would like to kick off with a question for the panel? I'm just looking for a hand up in the chat. If there's not a hand up, I will.
Can I just say something about the CCRC?
Please.
I know I've not shut up, but like I've said in the chat, they refused my case twice, and yet I've been found to have it unsafe. How can they be fit for purpose in any way at all?
Who would like to kick that off? Thanks,
Perhaps
Emma.
I can respond. Absolutely, John. I would completely agree with that. We've been campaigning for a long time. One of the things that, the report that the all-party parliamentary group put together, which was out last year. I put a link on it on the chat. They found that there were sort of systematic failings within the CCRC, but we think that it's to try and fix this in the easiest way without sort of getting rid of the CCRC in the first instance would be to look at the real possibility test. If there's any way that that can be improved, that may mean that more people like yourself, John, can be given justice, more cases back to the Court of Appeal. There's more work to be done there, of course, in getting cases over that really high burden, especially with joint enterprise cases. But I think if we start somewhere with that, then hopefully that may mean that more people will be survivors rather than prisoners.
Have they implemented one of them recommendations? They've not followed one of them.
That's very true. You know, it's been difficult. Yeah, it's been a difficult few years with COVID. The report itself was delayed. The CCRC did come out as being very supportive of the recommendations, but as yet, you're quite right in saying that nothing's changed.
Would anyone else like to come back on that one in the panel?
Can I come in, CJ?
Yes, please.
Thank you very much. So I would say that our experience of the CCRC inside justice is sort of multiple failings, really. We have terrific difficulties with them in terms of the length of time that they take to do absolutely nothing on a case. We have difficulties with them deciding in a very recent decision that we have on them on a murder case that was 13 years old, that they would not bother to do any of the new forensic tests that we had expert reports saying these new forensic tests should be done because it would identify who is the murderer here, objective new evidence. The CCRC decided in that case that they wouldn't do that because they'd spoken with the investigating police force and they were happy that the investigation that the police did 13 years ago was good enough, so we won't bother doing it now. I mean, there was some research which I think came via appeal actually, Emma, some years ago, which said that from CCRC minutes that there was a sense within the case review managers that it was actually easier not to do work than it was to do it, that actually making a referral was going to cause more work, and that was a real difficulty. So I think how we change that culture, that shift to make them into the properly curious investigative body which they should be is the real problem. And I really struggle to sort of see how we should do that. They make all of the right noises and they say, of course we welcome this from the APPG. But sadly, then the APPG, I'm sorry to say, doesn't really seem to have had much, fight and grit behind it in terms of saying, well, come on then, come on government, change this body, come on CCRC, make a difference here. So I'm, of course, the CCRC right now is hiding behind its multiple horizon post office case referrals, which change its stats and make it look as if it's doing a good and successful job in terms of its numbers, which is a lie. So I don't believe that they are a good and effective body. I think there are fundamental issues with that, with the organisation. I think that somebody needs to do a piece of work which is around the culture at the CCRC and how it, and Hannah Quirk, the academic, spoke very powerfully about this during the Westminster Commission. And that's the piece of research which I think really does need to be done in terms of how the CCRC operates and what the culture, because it has taken on a culture, in my opinion, it's taken on a culture of being, of sort of being able to rest lazily on its laurels, which are ones where they really don't do work and they don't do the work that it needs. But I think what we need to do is to raise awareness about this issue again. The old days of the media campaigning programs that would really bring awareness to all of this, the likes of Rough Justice and Trial and Error on Channel 4, World in Action, all of those programs did a great job and they've all died off. And that's my industry, which is at shame for turning its back on that. So whilst we've had this explosion of true crime stuff, and good on the Americans for doing that and making it interesting again, there is still no broadcaster here that is prepared to put funding into doing long-term investigations that turn up evidence for itself. And that's a problem, because if there isn't a spotlight on the on the failings of the statutory provision, the CCRC, and the Court of Appeal in the different ways that we've seen, it will go unnoticed, and loved ones will be left without a hope.
Thank you, Louise. Got a question from Nina.
It was actually just exactly on that point. I just wanted to refer to, because Jengba and Appeal won awards at our CJA Awards this year, Jengba for their campaigning work, but also Appeal's work with the Guardian Today in Focus podcast on the Freshwater 5 case. And, I listened to it and thought it was a really fantastic, way of getting across some of these issues to the public. So I just sort of wanted to say, what you've been talking about, Louise, how do we get some of these things, greater understood by the public? It's quite technical, it's quite jargony, it can be quite difficult to kind of, even people working in the sector, to kind of get sort of our heads around. So how do we get that message out to the public and actually to other bits of the sector? Like someone said, there's that ripple effect right across the system. How's we as CJA can help with that, and what other, methods can we use?
I was trying to ask if I could put my virtual hand up, CJ, and I nearly managed to record the session by mistake. So I'll just speak if I may. I completely agree with you, but I think we and the Guardian podcast was useful in reporting what had happened, but it didn't. But what the investment that we need to somehow persuade investigative broadcasters to do is to make the investment to come up with the evidence. That's where we have a lot of, I worked at the BBC for a long time. We get a lot of approaches at Inside Justice from production companies who want to make something, but they want basically for us to have done the work and then get it and then report it after the event. And that's fine, there's a place for that. But what we need for the investment to be made so that the evidence can be turned up. And that's the area which is still lacking. And that's where I think we really need to try and get some support. I think it is right and proper that when we have cases, and I think Jengba have been particularly brilliant at this, where justice is not done and people are really not being served by the courts, that those stories get out there. And I think it is important that we use the media to that end. I don't know whether or not there's some way that perhaps with the Criminal Justice Alliance, we should be talking more about this. How do we really identify those failings, that information failing? If it wasn't for Polish television and the private investigator that we paid for over in Poland, the new evidence in Patrick's case would never have been found. That took that kind of media collaboration. So I think we need to get savvy and a bit old-fashioned, a bit like the way we used to do it here in terms of trying to collaborate and work together to find the evidence, to find whatever it is that really drives change. If you think, sorry, I will be quiet in a minute, CJ, but if you think back to all of the old cases, the Birmingham 6 and the Guildford 4, when they had their convictions quashed, the Strand was closed. There were 6 lines of traffic that were being closed for people, crowds to be there. Cases happen now and people don't really know because it's not being reported in the same way. So I think all of those old cases and ours last year Inside Justice would not have happened without a massive collaboration between lots of people. So I think we have to join forces and drive change. So email me at Inside Justice, please, if anybody wants to collaborate, because we most certainly do to bring about good change for everybody.
Thanks so much, Louise. We've got no other questions. Just a lady called Kate, if you could contact Louise, she's given you her email address in the chat. And Emma for Charlotte was saying that it was really interesting what you were saying, and do you have the link to the members' bill that you could share with us? If there are no further questions, I just want to say thank you so very much to our speakers. It's been absolutely brilliant and an inspiring 2 hours to hear all of this. I'm going to hand over to Nina Champion for the remainder of our session today for a quick whirlwind tour around an update. Thank you.
Yeah, thank you so much, everybody. As a former recovering lawyer, it's been absolutely fascinating and really great that we can put a spotlight on this bit of the criminal justice system that sometimes doesn't get as much coverage. And we certainly are working with the media and journalists as part of our good criminal justice reporting work. So one of the things I was going to do is just update about what we've been doing since our last members meeting. And one of the things we've done is to publish a report called Behind Closed Doors, which is all about starting that conversation about what constructive and solution-focused journalism within criminal justice looks like. And we're hoping to continue working with the National Union of Journalists and others on developing that. So I'll definitely take the conversation we've had today forward with our communications officer, Jamie, and see how we can kind of incorporate that into our future work with journalists. We've also been working hard on our restorative criminal justice system strand of work. We have been working on an amendment in the police courts sentencing a crime bill, which is going through the House of Lords at the moment, trying to put an amendment down in the House of Lords about having a national action plan for restorative justice. Despite having cross-party support, unfortunately, it did have to be withdrawn twice, even though we re-amended it. Because the government said it would be a bureaucratic burden to have this annual report, but we will continue to fight to have this, because we believe that there needs to be a strong kind of leadership and strategy around the use of restorative justice and restorative approaches right across the criminal justice system, including in the courts. So we'll continue to do that, particularly in the Victims Bill, which is coming up. We are due to publish a report shortly around diversity in the criminal justice workforce, hence my question to Stephanie earlier, so that will be out in the next couple of months. We're continuing our work around our super complaint around the use of Section 60 stop and searches, and also about ineffective community scrutiny of stop and search. So that's ongoing with the super complainant bodies. And again, we tried to put in another amendment to the police and sentencing bill around Section 60. We also published a report. Apologies, my it seems to be flashing slightly. I'm not in a nightclub. It's a problem with my video camera, I think. So we published a report before Christmas, which we worked on in partnership with the Independent Custody Visitors Association, which I think are on this call. Real pleasure to work in partnership with them, looking at how visitors to police custody monitor equalities issues, in particular race and gender. And as a result, ICVA have published a race action plan, and we've also got the support of the Association of Police and Crime Commissioners for that piece of work. And our third piece of work we're doing on community scrutiny, which is around prison custody, which we've been working on in partnership with the Independent Monitoring Board, is due to be published again in the next couple of months, focusing on Black, Asian, minority ethnic women in prison. We've also been working on the Prisons White Paper, which came out recently. Many of you will know. Again, like the Victims Bill, very, very short timeframes to respond, including over Christmas, which is something that we're raising with ministers and with others. But we published a report called Purpose and Connection, focused on what more can be done around resettlement, to support people resettle, around employment and families, and also obviously putting down our opposition to the prison expansion plans. We have announced yet another role. So we mentioned earlier about we're going to be recruiting for a project manager for the Elevate Lived Experience programme on this Friday. And last Friday, we put out a job advert for a new one-year post on tackling race equality and race inequality in the criminal justice system. So we're looking for someone to lead some work on that with particular expertise in the public sector equality duty. So if you do know anyone, they don't have to have necessarily criminal justice experience, but if they've been working with equalities, equality impact assessments, public sector equality duty, please do share the opportunity. I'll ask my colleague Hannah, if possible, to put the job advert in the chat, but please do share that. It's on our website and on our Twitter account. And just finally, this is we're at the final bit of our Connecting for Change strategy, which was a 3-year strategy. We've been working with members, with our evaluator, with our trustees to formulate a new strategy, which we'll launch in April, which will be a 5-year strategy. And we'll be publishing the results of our external evaluation in the next month or so as well. So thank you very much to everyone who contributed to the ideas for the new strategy in roundtable meetings and conversations. It's been absolutely fascinating, and we're really keen to focus on how we get that systemic change that's been talked about a lot today. But yeah, I'll just say thank you very much to all our speakers today and pass back to CJ.
Thank you so much, Nina. It's been such a pleasure to host today, and really great to see all the comments coming through in the chat. Thank you for everyone for sharing all your comments and how to get in touch as well. I hope you have a wonderful rest of your day. It's getting a bit dark here, but enjoy the rest of your day and take care, and all the best.